We have the pleasure today of being joined by Linda Eggert. Linda is an interdisciplinary ethics fellow at the McCoy Family Center for Ethics in Society at the University of Stanford. And today we will be discussing her paper, Compensation, Proportionality, and Permissions to Harm. Hello, Linda. Welcome to the DDG. You can start whenever you are ready. Thank you very much for being with us today.
Great. Thank you so much for having me. And thank you to Andreas, Cecilia, and Maurizio for all your work and your wonderful job organizing this. Let me just share my screen. I take it that you can see the slides. If not, just shout. So what I'm sharing today is a work in progress on the following question. How does the prospect of compensating people for harms they have a right not to suffer bear on permissions to harm them in the first place? And I know you've read a draft of the paper, so I'll just give an overview of some of the main points by way of reminder. Broadly, the paper is an attempt to make sense of the intuition that harms that will not be compensated are, all other things being equal, harder to justify than harms that will be compensated. But the paper rejects the view that the prospect of compensation could render otherwise disproportionate and so impermissible harms proportionate and to that extent permissible. So here's what the paper does. 3 things. First, the paper considers a view that looks pretty compelling, and this is the view that compensation is internal to right proportionality. And this view says that compensation is something we can take into account in assessing whether harms are proportionate. So this means that the prospect of compensation can render harms that would otherwise be disproportionate and hence impermissible, proportionate, and to that extent permissible. But though it's attractive in some aspects, I think we should be skeptical of this view. And so the paper proposes an alternative. And my positive argument is twofold. In the view that I propose, compensation is external to proportionality. So this means that future compensation isn't something we can take into account when making wide proportionality assessments. But I also propose a conception of proportionality that is sensitive to the notion of compensability. And in this view, proportionality is sensitive to the degree to which harms are compensable. And basically, the first half of the paper challenges the claim that we should treat compensation as internal to proportionality. And the second half outlines the alternative proposal, which I argue is preferable for several reasons. So that's the high-level overview. Now, before I go into any more detail, here is one clarification and 2 assumptions. So first, my concern is broadly with what is and what is not relevant when we think about proportionality in the wide sense. So wide proportionality basically constrains the permissibility of harming people who have more rights not to be harmed, usually as a side effect in the context of lesser evil justifications. By contrast, narrow proportionality applies in the context of liability-based justifications, and my focus is on the former. Second, I assume that even permissible rights infringements may generate compensatory obligations. So I don't think that compensation is owed only for wrongful rights violations, and the relevance of this will become clear pretty soon. Third, and finally, I don't assume that compensatory obligations arising from permissible rights infringements necessarily fall on those who inflict harms on lesser evil grounds. So I think those who incur compensatory duties may actually be third parties, but that's just for context. Okay, with that, consider the following proposal. Zaber Besagen Forward has suggested that compensation is internal to proportionality in the following sense. So he proposes that inflicting a disproportionate harm, followed by substantial compensatory payment offsetting some of the suffering that the rights infringement causes, might result in a total amount of suffering satisfying the proportionality constraint. On this view, future acts of compensation that might offset some harm are included in the proportionality calculation that bears on whether inflicting that harm is permissible. Now, if this is right, then compensation exposed can help meet the proportionality requirement ex ante, which wouldn't be met in the absence of compensation. So again, in Besagen Forward's words, and this is the second quote on the slide, when evaluating an act that will infringe the rights of others, whether we will compensate those victims in the future can affect whether that act satisfies proportionality. So this is what, for brevity, I call the view that compensation is internal to proportionality. And I take it that we might find this view attractive for several reasons. One main reason is that whether people will be compensated intuitively affects the permissibility of harming them. In particular, it seems that harms that will not be compensated are harder to justify than harms that will be compensated, all other things being equal. And the second reason why some people might find internalism attractive is that there is a sense in which proportionality's concern is with the total amount of harm a person suffers. And if compensation, in effect, reduces the overall amount of harm victims suffer, we can see why one might think that compensation can help meet the proportionality requirement. So all this to say that I acknowledge the intuitive appeal of this proposal, and I think it's worth engaging with. But the devil is in the details, and in this case, in the precise relationship between compensation, proportionality, and permissions to harm. And in particular, I think the idea that compensation may render otherwise disproportionate and hence impermissible harms proportionate, and to that extent permissible, should give us pause. Now, before I elaborate, I'll mention just one objection one might expect here, but which I won't make. And this is that treating compensation as internal to proportionality would imply that pretty much anything goes. That if compensation can render otherwise impermissible harms permissible, this means that we may permissibly inflict any harm we like, so long as we compensate people afterwards. This isn't my worry, because I think as an objection, the proposal can easily escape. Basically, proportionality is a necessary, but hardly a sufficient condition for permissions to harm. Another necessary condition is that of necessity, and that effectively prohibits inflicting harms that exceed what is necessary to avert a threat. So even if future compensation could render otherwise disproportionate and hence impermissible harms proportionate, and to that extent permissible, I don't think that would necessarily imply that anything goes so long as harms will be compensated. So having set this aside, here are three worries that I think are generated by this view that compensation may be included in wide proportionality. The first worry is that by including compensation in the proportionality assessment, we treat compensation for harms victims have a right not to suffer as effectively legitimizing these same rights transgressions. And this is kind of a worry about double counting. The concern here is that including compensation in proportionality effectively takes compensation to justify the very harm which it is, in the first instance, meant to set right. But if compensation is a condition for permissibility, it seems it can't also be rectificatory. So, and so far as compensation is a rectificatory duty, it can't also serve to justify the harm which its purpose is to rectify. Now, this gets a lot more complicated in the paper, but in the interest of time and limiting complications here, I'll just move right on to the next worry, which is related. And this is that treating compensation as internal to proportionality manipulates the balance of moral justifications to generate justifications for harming that wouldn't otherwise obtain, by treating to be justified harms as already offset by future compensation. Now, what typically justifies transgressing people's rights on lesser evil grounds is the weightiness of some significantly greater good to be achieved. But accounting for compensation in the proportionality calculation adds a step. We practically discount harms on the basis that they're offset by some future benefit derived from compensation. So accounting for compensation in our wide proportionality assessment may generate a less evil justification for harming non-liable people, even though the harm we would inflict is, by stipulation, too significant to be outweighed by the greater good we would bring about. Now, I don't think this is just restating what internalism says. The worry is that we actually manipulate the justificatory mechanism to meet the wide proportionality threshold. And in this way, we can end up with a justification for harming people who have rights not to be harmed, but arguably might not actually obtain. Here is the third challenge. It seems to me that internalism is vulnerable to several ambiguities. First, if compensation affects proportionality, one question is whether this means that proportionality is sensitive to the moral difference between culpable and non-culpable failures to compensate. The second question is whether what should matter for internalists is that compensation could or will actually occur. And the final ambiguity is about how other agents' non-compliance with their duties to compensate might affect proportionality if compensation is indeed internal to proportionality, but compensation is owed by others. And in the end, I think that trying to disambiguate internalism in all these respects is more trouble than it's worth, because there's an alternative view, which I defend, that retains what's attractive about internalism, but is significantly more straightforward and avoids all these ambiguities. But first, here's the first ambiguity. If compensation can determine whether the proportionality requirement is met, this raises the question of whether there is a difference between culpable and non-culpable failures to compensate. So to illustrate, the Sagen forward says that if we know antecedently that civilians will be culpably left uncompensated exposed, it will be substantially more difficult to satisfy the proportionality constraint ex ante. He also says that if we're unable to compensate the victim through no fault of our own, compensation plays no role in calculating proportionality. Now, he qualifies this a little bit. My discussion in the paper is more precise, but one suggestion is basically that whether compensation matters for proportionality depends on whether the failure to compensate would be culpable. But I think it's hard to see the relevance of culpability for proportionality. Typically, what's decisive for proportionality is victims' total amount of suffering. And Sagen forward also assumes this. Now, it makes no difference to victims' total amount of suffering whether a failure to compensate would be culpable. So I think it's hard to see why proportionality should be sensitive to whether the failure to compensate would be culpable. Now, internalists could just concede that the distinction between culpable and non-culpable failures to compensate doesn't matter for proportionality, but they might still insist that compensation matters to proportionality in general. But there's a second ambiguity. And this is whether what matters is that compensation will actually be made, or that compensation could be made. So consider, as a rough analogy, the actualism-possibilism debate, whose concern is, very broadly speaking, with whether what an agent is required to do depends on what will actually happen or on what she could do. So suppose internalism is right, and that a given harm meets the proportionality requirement with compensation, but not without compensation. And suppose you know that compensation will not be made. Now, it seems that whether the harm is proportionate will depend on whether you think actualism or possibilism is right. If you're an actualist, the harm is proportionate only if compensation will actually be made. If you're a possibilist, the harm is proportionate so long as compensation could be made. Now, I won't take a stance on the actualism-possibilism debate here. My worry, is that there seems to be an ambiguity about precisely how the prospect of compensation matters for the view that compensation should be included in proportionality calculations. So it seems that internalists would need to commit to something like either actualism or possibilism before they can even assess whether a harm is proportionate. And that makes the principle of proportionality even more unwieldy than it arguably already is. Here's a final challenge. In some contexts, not least in war, compensation might only be possible in combination with others, or it might be owed by others entirely. And in such cases, a workable version of internalism, it seems to me, must provide an account of how proportionality is affected by whether others will comply with their compensatory duties. So suppose again that some given harm is proportionate only with future compensation in line with internalism, but assume that the primary duty bearers are others and that you know that they won't compensate for whatever reason. Now, if compensation determines whether the proportionality requirement is met, and if you know that compensation will not occur, it seems to follow that the proportionality requirement won't be met. But this isn't the only plausible view. There are cases, and this is the second half of the slide at the bottom, there are cases in which others' non-compliance doesn't affect the proportionality of your defensive act. So consider this case in which evil villain is threatening to break your leg, but if you break villain's leg in self-defense, then villain's friends will go break 5 other innocent people's legs. This is something that Helen Froh and Kim Fazan I've discussed. Now, the fact that defending yourself would entail that others will cause unjust harm arguably doesn't necessarily render your act of self-defense disproportionate. And I won't go into detail here, but one reason why we might think this is that those others would violate moral constraints that apply to them independently of what you do. So the proportionality of your defensive act might, for that reason, to some degree, be impervious to others' non-compliance with their moral duties. But if this is right, then it seems that others' failure to comply with their duties to compensate also shouldn't affect the proportionality of the defensive act that you'd perform and the harm that you'd inflict. But if this is right, then it would seem to contradict the claim that compensation is actually internal to proportionality. So I think there's an ambiguity about how others' non-compliance with their compensatory duties should affect the proportionality of our acts, which internalism seems vulnerable to. So to recap, I suggested that we have multiple reasons to resist the view that compensation is internal to proportionality, at least until it can address these concerns. First, it assigns a conflicting double road to compensation by taking it to both justify and rectify rights transgressions. Second, it seems to manipulate the justificatory mechanism underlying less evil justifications, so that the harm to be justified is already discounted by the expected benefit of compensation. Third, it's vulnerable to ambiguities about, first, the difference between culpable and non-culpable failures to compensate, second, the difference between actualist and possibilist perspectives, and third, how proportionality is affected by others' potential non-compliance with compensatory duties. But as I acknowledged earlier, intuitively, it seems that the prospect of compensation must bear on the permissibility of harming in some way. So for the remainder of the paper, I offer an account of what that might look like. And the view I propose is twofold. It says that compensation is external to proportionality, but it also says that proportionality is sensitive to compensability, in the sense that harms that are not readily compensable carry extra weight in proportionality calculations. Here's what this means. So basically, we're dealing with two different things. Duties of compensation as duties of rectificatory justice, which don't bear on proportionality, and compensability as a function of the severity of harms, which is a consideration informing proportionality. So to be clear, I'm not denying that compensation might bear on permissions to harm, all things considered. The view that compensation is external to proportionality just says that the prospect of compensation doesn't affect permissibility through proportionality. And one reason to think this is that the problem with failing to compensate intuitively isn't that it renders the harm disproportionate. The problem with failing to compensate is that this constitutes a moral wrong. So taking a step back, here's a main difference between the views that I'm discussing. So in essence, the difference comes down to whether we think that compensation is the sort of benefit that can be traded off against the harms whose permissibility we're trying to determine. So internalism presupposes that compensation can be traded off against the harms we seek to justify. So it's possible that to be justified harms are discounted sufficiently by future compensation to meet the proportionality threshold. Now, externalism denies that compensation can be traded off in this way. So to say that compensation is external to proportionality is to say that we can't, in our proportionality calculation, take compensation to discount the harms which compensation in the first instance says to rectify for all the reasons that I mentioned earlier. But this doesn't mean that proportionality is completely insensitive to questions about compensation. And this is where the notion of compensability comes in. Because what matters for proportionality, we might think, isn't whether a harm will be compensated, but the degree to which it's compensable. So I propose what in the paper I describe as the compensability rule, which says that the lesser the degree of compensability, the more weight the harm carries in proportionality calculations, and hence the higher the threshold of proportionality. Now, this basically imposes more stringent constraints on harmful acts that are non-compensable or not adequately compensable than on those that are readily compensable. I leave it completely open how to determine compensability. For my argument, it doesn't matter how we distinguish between different degrees of compensability, so long as we agree that we can distinguish between harms that are more and less readily, if at all, compensable. And one assumption here is that compensability is one function of harm severity, and that more severe harms are, all other things being equal, harder to justify than less severe harms. And in addition, we might think, if harms are so severe that they can't be adequately compensated, the foreseeable inability to comply with the requirement of rectificatory justice provides a reason against inflicting non-compensable harms. And this is why non-compensable and not adequately compensable harms weigh more heavily in wide proportionality calculations than readily compensable harms. Now, one might ask, why focus on compensability rather than the question of whether harms will or will not be adequately compensated? Because we might think that if we know that harms won't be compensated, then that should weigh more heavily in wide proportionality. But I think it matters why harms might not be compensated. So if people fail to comply with their rectificatory duties, that's one thing. If harms are so severe that they can't be adequately compensated, that's a different matter. And I think it's only this latter consideration that bears on proportionality. So I think we need to distinguish between two different reasons for why harms to innocent people might not be compensated. Because agents fail in their duties of rectificatory justice, or because the harms in question are of such nature that they can't be adequately compensated. And if agents fail to discharge their rectificatory duties, the issue is one of non-compliance, which should be addressed as such. By contrast, if harms are of such nature that they cannot be adequately compensated, this is a consideration that should bear on questions of proportionality. And that's why I make these two claims. And here is how this view avoids the vulnerabilities of internalism. By separating duties of compensation from proportionality and saying that proportionality is sensitive to the question of compensability, we avoid the worries about double counting and about manipulating the moral balance of considerations to generate lesser evil justifications, because we simply don't take compensation to play any role in justifying harms to non-liable people. And we also avoid all the ambiguities I identified, because again, since compensation isn't included in proportionality, we don't need to contort our conception of proportionality to account for potential failures to compensate, which may or may not be culpable, which may be a matter of uncertainty, and which may be a matter of others failing to comply with their duties. I think these are all really important questions, but I think we can better address them outside of proportionality. And in addition to these considerations, I think the externalist view has other advantages, and here are two, and I'll be very brief. So first, by raising the proportionality threshold for non-compensable harms, we effectively render wide proportionality more sensitive to individual rights. And this is in essence because compensability is concerned with the severity of transgressions of innocent people's rights as measured by their potential for rectification. And it seems intuitively plausible to think that rights transgressions that cannot be adequately set right, all other things being equal, harder to justify than those that are readily compensable. And second, the notion of compensability in wide proportionality that I've been appealing to, I think has a counterpart in narrow proportionality. So essentially, non-compensable harms should weigh more heavily in wide proportionality because they will cross a certain threshold of severity. Now, the narrow proportionality constraint on liability permits people to inflict harms on liable threats that exceed the harm that is threatened, assuming that's necessary. And cases in which that's true, arguably, are those in which the threatened rights transgressions, which render a threat liable, will cross a certain threshold of severity, characterized, arguably, by a harm's degree of compensability. So the notion of compensability plausibly plays a role in both narrow and wide proportionality. So, to recap, I argue that the prospect of compensation has no bearing on wide proportionality. What matters for proportionality, I suggested, is the degree to which harms are compensable. Harms that are so severe that they cannot be adequately compensated carry more weight in proportionality calculations than harms that are readily compensable, irrespective of whether compensation will actually occur. And treating compensation as external to proportionality in this way allows us to hold on to the intuition that harms that will not be compensated are, all other things being equal, harder to justify than harms that will be compensated, which is what's appealing about internalism. But externalism allows us to explain this without either presuming or implying that prospective compensation can render otherwise disproportionate and hence impermissible harms proportionate and to that extent permissible, which would get us into all kinds of trouble. With that, I'll conclude. Thank you very much.